Good evening to all of you. For next about 30 to 40 minutes, I'm going to talk about 5 topics that are relevant from everyone's perspective, and then possibly leave most of the time for question and answer, because I understand that some of the issues do not have a definite answer, and to the extent I'm able to provide clarity, I'll be most happy to do that. So bear with me for some time, and then it's going to be open for Q&A. I should say that, look, when I spoke last at the HRIF forum, I did not have specs. We did not do the session on the web. It was all in person. And there's nothing like, the touch and feel of meeting people and, looking at the body language and exchanging notes. Of course, these are different times, and this is the first time that I'm speaking at HRI webinar. So, this is of course going to be a hit and trial for everyone. I have done almost 18th webinar in last about 8 weeks, and I have now learned the art of speaking to the wall and to the screen more than to the audience in front of you, which I'm more used to and which I enjoy the most. And I hope that we get together real quick and fast, and hopefully, get to see each other. And some of the conversations today are also in line with how do you get back, and what is it that all of us, and everyone, it's not just the HR, it's not the admin, it's not the legal, it's not the top management, it's a collective responsibility. And what has come and hit us has taught us that this is not one person's job. Okay, this is not just an HR issue, this is not just an admin issue, but this is all pervasive, and everyone has to step in to make sure that we are all safe and everyone around us is safe. Lot has been spoken about the regulatory environment, and it has been a challenge in terms of navigating last 2 months, especially when it comes to the payroll. And this is the third time that the payroll is going to get processed. It was in the month of March when everything was effectively in a lockdown situation, and so was the April. And everyone at that point in time thought that 3rd May is when we open, and now we are 1st June. Everyone expecting that we will open, but we are not too sure as yet. And therefore, if you saw what has happened is the government also has been reacting to the ground level situation. So has been the Supreme Court, and so has been the Labor Office. And some of you might have been victim of the regulatory overreach, as I call that, at this time. And everyone is trying to figure out as to what is the right and what is the wrong under the law. What happened was, there was a notification that came from Ministry of Home Affairs on 29th of March, and this was just 2 days prior to the payroll process. And there was confusion all over as to what would it take for us to process the payroll. Can we, should we, what are the ifs and buts? Most of the people, without going into details, did process the March payroll without much ado, because we already had worked for 20 days in person in office, and then the 10 days was scramble all through for everyone. And then the April happened, and the reality started to come to everyone in terms of what does it mean and what does it have an impact on. And small little things, that there are performance issues, there are PIP issues, there are misconduct issues, and so on and so forth. And what does that mean from everyone's perspective? Remember that what I'm talking today is not a legal advice, but this is a collective understanding that I possibly have gathered speaking to friends like you. And I'm going to share that as my experience in terms of what we have seen and what we continue to see in the industry. And again, as I said, that we will have opportunity to do Q&A, and I'll take specific questions as I complete my quick conversation, as I want to lay down the table to Abhi to relay the questions to me. So what am I talking about on the regulatory side? The regulatory side has two angles to it. One is that with the latest Ministry of Home Affairs notification that effectively took out the whole conversation away in terms of a superseding clause, and it says that all other things, that all other orders which were part of the earlier regime has now is not going to be applicable henceforth, which means that the 29th March notification is not applicable. And on the basis of that, when the state government actually issued, a lot of state governments issued the order, all of them now have no bearing at all, which means that the status which prevailed prior to 29th of March is now the reality. There is a small chance that the Labor Office may still come after some companies, but that's a different story altogether. That was happening even pre-COVID, and therefore one way of looking at things is from the labor law or employment law standpoint. We are back to COVID, rather we are back to pre-COVID situation, and that's a very, very important change overall from all the HR practitioners, or for that matter any leadership team, because it has an impact overall on the organization. And therefore it is important to understand that while there were ifs and buts, those ifs and buts are more or less over. There are certain petitions which are still pending with Supreme Court, but those would become effectively superfluous given the fact that the government itself is now not insisting the fact that someone has to be paid wages come what may. And that was something which was industry demand, and people thought that either the wage bill has to be taken over by the government to a certain extent, or else the order should be set aside. And what happened was, obviously the economic stimulus that we all saw had some things to do with the payroll, and we will speak about it in a minute. But more importantly, it did not, unlike in the US or Canada or some other countries where the payroll protection plan has been put in place, we did not get that as employers or MSME or small companies, and which meant that that order has now therefore been put to rest, and we have a pre-COVID situation as far as our essentially the employment law are concerned. So what does that mean? It means that, for example, if you were to terminate someone, what do you need to do is something what you actually did prior to 29th of March 2020. Okay. Now, whether that process was right or wrong is something is not today's topic. But the fact is that the actions and the process that you were to follow and ought to follow has now been restored. And if you follow those and provide a natural justice to an employee and give and run through the contract, effectively you should be not getting into any regulatory tangle. Remember that the Industrial Dispute Act is applicable to IT companies. That is something which is very clear. The layoff, the retrenchment, all those provisions apply to the IT companies. But importantly, there are certain nuances in those acts which allow you to run your show the way you would want it. There are IT policies by the government. Those come to your aid. There is Shops and Establishment Act, which is something that we all follow in the IT industry. And when you read all of these things together, you should be in a position to come to a specific answer to a query that you might have in terms of terminating someone, cutting wages, and what have you. I'm going to also talk a little bit in terms of taking consents of your employees while you make any change to the employment terms. Remember that the employer and employee relationship is effectively guarded by way of an engagement letter or an employment letter or an offer letter, by whatever name you call. And when you have that particular situation, you when you make any change to that, unless both parties consent, that actually may not have a validity, because at the start you took approval and consent from both parties, and now if you were to make any change, be it positive or negative, unless that's consented by both parties, it is it is subject to obviously interpretation, and it could lead to certain undesired consequences, as I call them. You must ensure, therefore, when you are making any change which is adverse or positive, like when you change the salary, you would effectively go and say, guys, look, we've made the change, and you acknowledge so that we can process your compensation. In the same manner, you need to take consent of people as you make changes to their employment terms and conditions, including compensation, be it upwards or downwards. And therefore, very, very important. And I know there are large companies, there are logistic issues, but importantly, in these times, if you don't do your housekeeping well, you are susceptible to something which might bite you, and the time that you will take to answer those unrequired questions from the regulator possibly will eat more time than what it would today to complete your paperwork. So therefore, when you are doing any of these changes, make sure that you are taking consent from your employee, and at that point in time, once you record it, it should be all right. The consent could be as an email response. The consent could be in whatever form. There are electronic signatures now which are available. There are electronic platforms which are available, which give you authenticity in terms of what you need to do as a consent. And once you have that, you have peace of mind. And therefore, on the regulatory side, two things have happened. One is the situation is more or less restored back to pre-COVID. And two is the fact that your documentation is coming to the fore. And once you take care of those, I think we are more or less, coming out of this without much ado. Those who face some issues with the labor office, I'm sure they possibly are now over that, or in the process of getting over that, should not make a huge dent in the overall scheme of things. I know it's easy to say in these seminars, but when you are in that particular situation, it's not easy, and many of you possibly have front-ended those. So those are not easy situations to deal with, and I fully sympathize with you and those who got impacted because of this COVID-19. The second aspect is the Provident Fund change that came to ease the liquidity in the hands of the employee, making it from 12% to 10%, and also for those. And I don't know if there is any company which is present at this on this webinar where there was a complete takeover by the government in relation to the employer and the employee contribution for those who were less than 100 people company, of which 90% were drawing less than 15,000. So I don't anticipate those people on this webinar, so I'm not going to deal with that in any way. But from the Provident Fund change, it obviously is a small one, which makes it from 12 to 10, but it has an administrative hassle. And remember that this is a short-term measure, which means that in next 3 months, you're back to where you are today. And therefore, you have to be very careful in terms of how you document it and how do you make sure that, your returns, forms, and everything is filed in line with what you are, looking at. Remember, if you continue to keep the as a organization, if you continue to keep the compensation same, the law allows you to do that. There is no problem that if you say that you're going to do 12 and 12 as what is your current policy required previous to the relief that the central government has given, you can continue to do that to avoid administrative hassle if everyone is in agreement. But if you think that liquidity is an important criteria for your employees, then obviously you have to run through the process, but make sure that the follow through on the process is equally correct and well done, because it may have a ramification of reconciliation at a later point in time, and you are again bound by a lot of work to undo what you possibly can do right in the beginning itself. So that's a major important change. And obviously there have been certain changes. I don't know if you deal with those, but in terms of the Provident Fund ESIC filings, there has been a leniency in terms of the timeline within which you could file this with the regulator, and therefore if some people would want to opt for those timeline advantages, please opt so, including the fact that there has been a clarity that came from the PF office recently, where they said that if there has been delay in depositing the PF for whatever reason, they will not take any action, nor will there be any penalty. Some people are reading between the lines to say that can they delay the payment, but obviously the relief is only for a genuine good faith situations which have created a delay in terms of deposit, but that should not be taken as a diktat by the government to allow a late payment of Provident Fund. Remember that we all owe it to the government as well, in terms of making sure that those who have and are able to must do that, because it's all going to have a reflection back into the economy. So that's on the regulatory side. I'll take more questions as we go to that at the end of this particular presentation. But that's a good relief, and I was hoping when we spoke last week with the HRI team that the clarity comes and is just bang on. We have a good respite, and which is more logical, which is more humane to the employers as such. And I'm sure everyone is a good employer and will make sure that it's used in a proper way as it has been in the past as well. So that's just a quick note on what is the regulatory landscape amid COVID-19, and more as the questions come. The second thing that I'm going to talk about is the work from home as a concept, as well as the overall euphoria that has emerged with the work from home. And I'm included in that. You tend to now feel a little different when you have to go to office. And when thanks to HRI, when I put a shirt instead of a t-shirt, it felt a very, very different thing, because this has been and when I was told that no, you have to be on the video, and I said, okay, I at least need to put a shirt on. And that's a huge change, right, in terms of how you conducted yourself in last 63, 64 days. And I don't know how long that will continue. Now think about it in terms of the work from home, and look at it as a whole company policy. Earlier, it was optional work from home, and most of the policies had this approval, had this, what you need to do, get me manager's approval, you need to give a proper reason, you can't go do work from home for more than 4 days in continuity, and, bunch of conditions. And today, people jokingly say that it's now going to be option to work from office, right? And that's a big, huge change that everyone is grappling with. The question is, should there be a work from home policy, or should there be a work from office policy? And we're going to talk both as such. Those who go back to office post opening, how do they do it? And those who are, continuing to work from home, what should, as an employer, we all need to think about to make sure that, this is from our customer standpoint, our vendor standpoint, our employees, co-employee standpoint, all kosher, and we are not, getting into any kind of issues. I'll tell you the issues that we have seen as legal logic in last few weeks. For example, you have a POSH as a policy, right? POSH is well known; everyone knows about it. Now the question is that if I'm ill dressed and I come on a Zoom call, and that has an implication in terms of how it is perceived, does that become a harassment? That's a question posed to us, and I don't know the answer to it, by the way. Okay, I don't have answers to everything, and we were surprised to the fact that someone felt harassed by someone not dressing well when they came on a Zoom call. Okay, and that's a level at which we are going to look at a situation when work from home become mainstream and becomes something which is which is now essentially a way of life. Second thing that comes to my mind is that if you are doing Teams, if you are on Teams, you can't delete your chats. If you see, you can't delete your chats, and it's actually awful that if someone in a very good faith and in a as a joking situation writes something, can actually bite him, okay, because you can't delete it. It is actually visible, and there is a backup that gets created on the cloud permanently, and you have a situation that you're dealing with. And therefore, it is very, very important in terms of making people aware as to what tools that they are using and how those tools have an implication in terms of their conduct in the way they are doing it at this point in time. And remember, some of those may be unintentional, but could be used against the employee for various reasons. And as what we used to do before in terms of a system administration training as to what can you download, what you should be doing and what you should not be doing, it becomes very important and critical for people to understand as to what are the do's and don'ts while they are doing work from home. Very, very important. And remember, you have a situation where there are new joinees coming into the fore. They have no understanding about the company. They are being inducted with electronic way, and they are not. They don't have advantage like you and me have working in an organization in the past. Those are college freshers, right? There is a bunch of college freshers waiting in the wings to join, and that's going to be a very tricky situation in terms of making them aware as to what is right and what is wrong. The many people who are using their own machines because they got onboarded and there was no time for you to actually actually ship them machines, which meant that many of them started to use their own machines, and you are now in a situation where many of them possibly in 2 months time you figure out that person is not working out and he may not be continuing in next few months, but he has data. How do you take care of those? All of that becomes very important and critical as you allow work from home as a mainstream situation. Remember, from an HR perspective, that's like a real tightrope walk because of the situation that you are, wanting to make sure that in these trying times, you are not being overbearing on the employees with loaded policies, because one, it's difficult to sit ergonomically in terms of a chair, a table. People may not have large houses, so you're grappling with all of those things. And on top of it, if the employee is subjected to more stringent measures, it has a lot of implication in terms of how all of this will pan out. And therefore, it is important to understand the business reality and marry it with what is required from your customer perspective. Overall, what kind of measures that the customer is expecting you contractually. Remember that the contracts with the customer on the confidentiality, data privacy will not change, will become more stringent, will be more, effective, and they will start to look at, and we have already seen companies asking us as to can we ask for leeway in terms of the confidentiality, in terms of data privacy. And I told them that, look, you are opening a Pandora's box that will effectively derail in next 3 months a different vendor that they would want to onboard, because you don't have a system to keep their data secured in whatever shape and form. People may give you 10 days, and those 10 days have already gone, by the way, but they won't compromise on their security as well as the confidentiality of data. And from that standpoint, it is very important to make sure that your policies are tuned to those aspects, knowing fully well as to what you are working for is end of the day a customer, and he's what is going to determine whether this work from home policy will be an effective policy from a customer contract standpoint or not. So what needs to be done is the fact that you must understand that when you are creating this policy, you're looking at a system administration issue, you're looking at a customer issue, you of course have to look at the employee issue, but you also have to look at the logistics, infrastructure, and on top of it, there are regulatory issues which have a bearing in terms of how you would conduct and continue to have work from home as an effective measure. So if you see, the Department of Telecom has allowed till 31st of July, the OSP license, which is effectively required for a lot of telecom related aspect, that has been put to rest, and exemption has been given till July 31st. So has the SEZ. They have given a relaxation till July 31st, and hopefully that will get all increased to a situation where we get back to normalcy. But the fact of the matter is that we have to keep looking at all of these situations on a very regular basis and make sure that we are following it to the T and learn from each other in terms of what is the best practice as such. The other issue of who actually is working for you is another big issue, and we have seen this enough. Like in the past, when someone is writing an exam, whether it's the same person or not, how do you determine it? And it's going to be a tricky situation when someone is working from home, whether it's the same person or is that person outsourcing his work to someone else, and you're continuing to pay the compensation assuming that it's that person who is actually delivering. That all is a very, very important situation that we all will grapple with in terms of how do you ensure that, at least once in a day to start with, and as it ends, as you had a biometric, what is the biometric from work from home? What is a biometric equivalent which is secured enough from your perspective? That would be very important and critical to understand. And there are no yes and no answers. This will evolve, but it's important that you start to look at what are those things that you would want to put in your work from home policy. And remember that you don't want to go overboard, as I mentioned, but importantly, when you are training your employees and you're communicating to them in terms of what are the do's and don'ts, they would more often than not behave in the manner you expect them to, and make sure that the customer does not come back to you with some unwanted questions and unwanted situations. Remember that this is very competitive at this time, which also means that one mistake and you have a situation where either you will have to drop the price, or the customer is no more your customer, and you are again going back to a situation where you have some unwelcome questions to answer from the employees and in turn the regulator. So it is all connected, and therefore has to be looked upon from the HR perspective in a very different manner than what it was done in prior to this COVID that hit us. The second aspect is that the corollary to it is that not everyone can work from home, right? Some functions have to be in office, some functions have to be in the field, and life is slowly but surely coming back to normal. So then what am I talking about? When you are trying to open post lockdown, there are SOPs which have already got created. The SOPs have been published by the government. The Home Ministry has given a detailed rundown on what is required to be done. And I don't want to, bore you with what you already know, but it is important to make sure that if you're working from your own premises, how do you deal with it? And when you're working from rented premises, what is it that you are expecting your landlord to provide as a basic preventive measure is very important as such. Now, we have got several questions with regard to the latest notification that came from Ministry of Health and Family Welfare in line with the Ministry of Home Affairs notification, and they have broken the overall guideline to prevent spread of COVID-19 at workplaces into four different categories, if you will, in terms of what are the basic preventive measures which are always to be followed, what are the measures specific to an office, that is a unit, what are the measures that you take when you are when there is an occurrence of one case. They are saying that if there is only just one case, you don't need to shut the whole office. If there are two cases, you don't need to shut the whole office. But if there are more than those cases, then they will take a little more severe actions in terms of disinfecting the overall place. And I know that everyone is going to take care, but it is important to do the following, in my opinion. One, do the minimum what the government is expecting, and two, given the fact that your location and your place is unique to yourself, it is important to understand as to what is the best way you could protect yourself and your employees in these times. It is important, before anything that starts, there is a recce that happens, and there is a video that you shoot every time you disinfect and you take care, you take measures, so that you are able to keep that as an evidence. If at all some untoward incidents happens, you still have an evidence of you doing what you are supposed to do as an employer, because this is this is going to be a situation where you have to continue to follow these things. And remember that you are taking help of your office assistants, you're taking help from housekeeping staff, and all of them have to be trained, because the responsibility on all of this has been cast on the head of the organization. So remember that it is not just the person who is in charge of the function is being impacted, but the employees obviously are impacted, but the responsibility is cast on the head of the organization, and which has a ramification overall. If you remember, there is a requirement to provide transport facility to female employees after 8:30 p.m. Okay, that's what the Maharashtra Shops and Establishment Act requires. And we also know the past NASSCOM chair who actually got impacted because of the severe action that got taken against him, because he was leading the company and some untoward incidents happened. And in similar way, on COVID, while there is no criminal angle to it, and that has been put to rest, because earlier there were rumors floating around that if you open and something happens, then the employer will be caught. No more so, and that has been put to rest. So no question about it. There is no question of any FIR being filed or any criminal thing being followed. But remember that if the employer is callous, then according to the Ministry of Home Affairs notification, there are situations that will pan out, and the employer may have to answer some unwelcome questions. And therefore, it's important that due care is taken both from the safety of the employee, but also as an employer, as a responsibility to make sure that the head of the organization is not taken to task for something which is an avoidable thing. One of the questions that has come is, who bears this cost? and unfortunately the employer has to bear this particular cost. There's no other way of looking at it. It is added cost for sure, but we know why the cost is added and what is it that we are effectively doing it for. And therefore, the cost is not something which is an important element. The safety is what it is. We have gone through last 2 months debating whether to pay or not to pay the employees. Now, this is not the time to debate whether this cost is to be borne by the government or by the employer. It is very clear that the government can only do so much, and the government is doing possibly what it can in the limited resources, both of money and manpower. But it now becomes a responsibility of the of each employer to make sure that the place is secured and is looked upon in a manner as is expected in the SOP. But I'm sure we will go beyond the SOP and then use our own wisdom to make sure that our workplace is effective. We have to look at both the work from home and work from office policy in tandem, because not everyone for all time is going to work from home, and not everyone is going to work from office all times in the near future. So we are obviously hearing that there will be a rotational basis on which people will come in office, will work from home, and so on and so forth, and all the permutation combination, as you possibly have heard, are contemplating. But therefore, when you are looking at creating a policy, you must have clarity in terms of when you are working, and the same person, remember that the same person is going to work from office and the same person is going to work from home for a foreseeable future as such. And therefore, when you are making a policy, make a policy which is in tandem and is supplementary to each other and complementary to each other rather than in isolation. Abhijit, I think I'll stop. I'll talk about the last part as best practices at a later point in time. I think maybe a good idea to take few questions and see how it goes. I mean, so look at the situation where if it's a reverse thing, where the employee were to leave the company without notice, what action would you take? Is the same thing that the employee also has the right to take against the company. Okay, so it's like, it's a two-way situation. It can't be seen as a one-way situation. So if someone is terminated without following due process, obviously the law in India is not a hire and fire situation. If you look at the standing orders, if you look at the shops and establishment, you look at the Industrial Dispute Act, all of that gives you a clarity in terms of the process that needs to be followed. And obviously, if someone is in probation, it's a different situation. But if someone is a permanent employee, then you ought to follow the process. Else, as you would expect the employee to follow the process, the employee would not be wrong to expect that the company follows the same process as well. So, we've heard both situations where people are saying that we don't want to work from office, and some people are saying we don't want to work from home. Now, the policy has to be framed by the company, and the policy has to be such which one is minimum to the minimum level is compliant with what the Ministry of Home Affairs guidelines are. So what the guidelines say is that as far as possible, and mark my word, they say that, you should continue to work from home, but they are saying that 50% of the total capacity can continue to work from office. Okay. So it is an advisory that the government is saying that to the extent possible, and for those it is possible, they should continue to work from home, but they have also relaxed, except for those employees who are in a containment zone. Except for those, everyone else who can come to office, provided that number doesn't exceed 50% of the total capacity of that particular organization. think what now has happened is that with the May 17th order of Ministry of Home Affairs, the restriction and the diktat of doing of not terminating or cutting wages is no more applicable. So if you follow the process laid down under law and in the contract, this should be possible now. So, what we have seen is that the union is going to the labor office, and labor office attaches the letter of the union and expects the company to respond to the labor office. So the company, of course, has to respond to the labor office notice if it receives. But, if there is a union which is not registered, not recognized, you don't owe any response to anyone in a random situation. If those are not recognized bodies, and in most of the cases these bodies are not recognized by the company and they are not registered as well, you don't owe any response to them directly, or for that matter media asking this question. You may for right reasons or wrong reasons you might want to answer, but you're not obligated to answer as such. I think what comes in media is not even half truth these days, right? And what comes in social media is not even 1/4 truth to the story. And what got reported is that, and which is not correct, which is not incorrect, that they effectively have proposed to suspend. It came as if everything got suspended. Remember that the labor is a concurrent subject, which means that the state and the center both have to agree to do that, and there is a long process before which those changes can be effected as such. And as you saw, Uttar Pradesh has already taken back those changes, and with the protests that happened, first thing that they did was to withdraw the notification. So it's not as easy as it looks like. But remember, there is a wage code which already is in vogue and is awaiting a final nod to become a law, because there is a final aspect remaining, and we are hoping that it could have come to the fore. But now with COVID-19, it's anyone's guess as to when it will come back and become implementable law. But the framework is very clear. There is going to be a substantial change in the labor law as we see it come. It is one of the major reforms that is already with each one of us. We can study them. We can start to look at. There's been a lot of debate surrounding that. The implementation of it, when it will start to happen, we have no idea. But all of the major laws have been now combined, and the effect of it is that if you had 40 laws that at any point in time a company were to comply with, it's going to be combined as 4 laws as such. And there is a fair bit of debate that has already happened, and we are very clearly going to see hopefully soon something which is more in line with what the business requirement is. Also remember that some of these situations, IT industry is a very different industry, very compliant, extremely careful in terms of, because manpower is the biggest strength and our biggest asset. And we use all of this with kids gloves, as they call that, right? I mean, very carefully. It's a tight rope walk, and therefore you look at IT industry in specific, and then look at the manufacturing industry. The practices that you follow in the IT industry and the practices that are followed in non-IT industries are extremely different. And therefore, when you are looking at a law which is all pervasive, which is applicable to both the services industry, IT industry, manufacturing, and what have you, you have to consider everything. And India is not just the top 5 cities. Unfortunately, the top 5 cities account for major cases at this point in time. But Remember that five cities is not India. India is a large country, and to create a law which has which will be applicable with all that intensity across is not easy way altogether. And therefore, expecting that all the changes that the IT industry expects will be coming forth in the change law is not going to be the reality. The reality is going to be that the employee will and has to, because the employers have a major it's an asymmetry, right, between the employer and the employee in terms of the relationship, and therefore the laws will continue to favor employees to a large extent. But the procedures which are archival procedures at this point in time, they will definitely get eased. Okay, that is what the industry expects. The industry expects that the process today of someone visiting without notice and putting gun on the neck is not something that is welcome, and all of that is being very clearly addressed in the change regime, and you will find that it would be welcomed by everyone. Remember that if you go to France, if you go to other countries, the laws are more stringent than what we have in India, but the implementation of that law is very fast and quick and very transparent. What we expect as industry and what we expect as practitioners is the fact that the procedural part has to get smoothened out. Otherwise, you are in a situation where you have a double whammy. One, the law is complicated, the procedure is complicated, and then it is only one-way traffic without anything for the employer as such. And therefore, a little bit of balancing, more importantly on the procedural aspect, will give a lot of respite to the employers, is what my opinion is. And again, these are the times when the freshers join, and these are the times when you would expect the onboarding, and I'm sure there's a lot of work going on in the HR teams. What is a contract? A contract is what we call as an offer and acceptance test. You give an offer, the candidate accepts it, that becomes a contract. Okay, as soon as offer is accepted, that becomes a contract. Whatever you look at, that's what the law says. Now, if you have given an offer and the candidate has accepted that offer, then that's a contract, and you have to then follow what the contract says. Now, the contract might say that you join and I can terminate you within your probation without any notice. So he joins and you can terminate. That's as per the contract. Okay, no problem. But if your contract, with the offer letter that you have given, has a particular clause that effectively helps the employer to say that till you are joining, I have an ability to say whether you will join on this date or the other date. If that is a contract that you have created, and you have a contract to say that you will let him know what is the exact date of joining, then you have the ability to delay that particular thing without he consenting to it. But if there is a contract which the offer which has been accepted and has become a contract, and you don't have a leeway, then it would run exactly the way the contract has been written, and therefore you have to follow what is there in the contract. And this is bound to happen where what you call as there is a disagreement between the employer and the employee, right? I mean, the employer is asking something to be done, and he's saying that, look, this is not just for you, but we're doing it for everyone. And if you're not in agreement with the company policy, there is no other way but, there will be a separation, if not today, tomorrow, if not tomorrow, day after. The fact that someone is unwilling to live. So, for example, you are admitted to a theater, or you are admitted to a cricket ground on the basis of some terms and conditions, right? And it's the same thing that you admit an employee on certain terms and conditions. Certain things are acceptable and certain things are not acceptable. Now, of course, as I mentioned, that it has to be with the consent of the employee. And if the employee does not consent to this, then you have no option but to, look at an alternative which may lead to a termination of the employment because there is no agreement between both parties on something which is critical. I know for a fact that if it's a trivial issue, you will not go at length in terms of enforcing what you would want to otherwise enforce. But if it is something which is fundamental to the existence of the company and the culture of the company, and if someone is not willing to do that, then you may not want to continue. For example, there is we recommend that all employers should have a invention assignment and confidentiality agreement against their employee, and this comes with a lot of experience in terms of how in the past, in my experience while I was in house, we got shunted by a couple of people, and we at that time took a policy call that we will not negotiate, come what may, at whatever level a person were to join. If he says that I cannot sign that document, we don't want that person to join, and we are very clear about that particular aspect. Now, you as a company lay down contours of what is right and what is wrong, and if someone doesn't live with those particular things, there is no other way but you will separate in terms of the relationship. So it is the same thing where if you were to look at it from the employee standpoint, if it's a concluded contract, then the new employer ought to honor that. And according to the contract, whatever are the consequences if the employer doesn't honor, the employer will have to face if the employee decides to take legal action against the employer. It all would depend on how the contract has been written, what are the obligations of the employer, and what are the consequences of not honoring that particular contract. The employee will definitely have a right under law and in contract, both together, to take relevant action as he or she chooses to. Again, there are two things to it. One, I'm not going in terms of the humanity aspect of it. The legality of it is as follows. The legality is that, if you have followed the process as per the law or the contract, you as an employer can take that particular action. Now, whether a termination on Zoom call without a paper is valid or not is yet to be tested, because Zoom's valuation has increased only in these COVID times. But a legal issue arising out of a situation like this, is difficult to fathom as to how the courts will eventually decide. But remember that if it is a verbal communication, and most of our contracts require a written notice, right? That may not pass the test of the contract itself. So if you look at your employment letters, you would expect your employee to give a notice in writing when the person is wanting to move out of a particular organization. And in the same breath, as a reciprocal thing, that when you are terminating someone, unless there is a official communication by way of a letter, it may not have a validity in itself. And what has come in the press is just the half truth, I'm sure, because what has been informed is informed on the call saying that this action is coming. I'm sure those companies are advised properly, and they would have followed it up with the proper paperwork, which means that there would have been a termination letter or a separation agreement, a full and final settlement, and all the related paperwork. It's just and therefore I said that what you hear on the social media and in the media is half or less than half truth as such. That may not be the entire story, Abhijit, as such as that it has come out. Of course, it looks very dramatic that, and very inhuman that a 3-minute call, kills a relationship built over time. But I don't think they would end it like that. There would have been proper documentation. And in that way, documentation is a must, and following the contract. And most of the contract would require in writing, both from the employee side and therefore from the employer side as well. If I'm an employee and my consent is not taken, I have all the right to feel offended. And, if it's then it could potentially be a breach of contract, because remember, what is the contract? The contract is that the employer employs a person on a agreed compensation. And if that agreement is being changed, unless I consent, you can't assume my consent unless I actually have consented to. That's being taking me for granted. And if I feel offended and I take action, it may not be against law. And the law as well as contract both will allow the employee to come after the employer. And we therefore don't recommend it during COVID, pre-COVID, or post-COVID. Any action which is adverse to employee without documentation and without consent and without proper wording, we don't recommend it at all. It could be an email, it could be whatever, but the consent is required when you make these changes as such. Okay. See, Abhijit, one of the things that we have seen is when does a person get really disgruntled and feels offended is when he is informed all of a sudden without any notice in front of everyone. Remember that in India, people don't like personal issues to be discussed in a public forum. So if if is a Zoom call happening and someone, gives, it may be a right, the person may deserve a comment like that, but I may get offended if you make a sidey remark against me, even though it is a true thing as such. But if you do it one-on-one, if a leadership team does that, it has a very different impact altogether. And therefore, we've been recommending that, if you want to avoid legal issues, you must take care of things which would not offend a particular person. And if you do that, more often than not, a person remember that everyone is impacted. It's not one versus the other. Everyone has been impacted, and employees do understand that there is a hardship. But if it is explained well, more often than not, you will find that, the relationship is intact and the damage is less, and you can spend that time to avoid a bandwidth issue at a later point in time, because we have seen that the whole top management starts to get on call saying that, "Arey Vivek, this has happened, now what to do?" And there is no yes or no answer at that point in time. You are just doing a post-operative situation that is to, prevent at a later point in time a damage that already has happened. And, my last aspect is in continuation with what I'm talking about is the best practices. And I have spoken about this in the earlier forums as well. What the recommendation is that you must revisit your documentation afresh. What document you used, what policies you used pre-COVID may not work post-COVID. Okay, they will not work if you are just going to copy what has been in the past or continue to follow what has been created at this point in time. It is important that they are debated. Again, there is no yes or no answer. There has to be a debate in the forums like this, in your organizations. What kind of culture are you wanting to build as a company is all very, very important. I read one of very good articles on LinkedIn by Vikas Joshi, who is this chairman and CEO of Harbinger Group, and he said that all of us need to write for ourselves as to what do you want to be post COVID. And he was talking as individuals, what do you want to be? But I think it is important as an organization as well, what do you want to be? And that has to reflect in your documentation, in your appointment letters, in your separation agreement, in your employee manual, in your overall policy and framework that you are looking at. It has to reflect what is the culture that you want to endorse post-COVID, or as soon as you open up, or during this time as well, because life is not going to be as what it was 8 weeks back. And therefore we are recommending that if you have done your documentation some days early, some weeks early, some months early, some years early, this is the time to revisit all of those and make sure that you are reflecting the culture that you would want to live with. That's a very important situation. Now let's pick up one aspect of it. Okay, I spoke about work from home policy, work from office policy. That's just a reaction to it. But think about a leave policy. Okay, what is it that you want to now advocate, because people have been working all through without break, possibly, because what else do you do, right? I mean, you're at home, there's nothing else to do, so you work, right? Now how do you want to put that as a policy? Leave aside what the law says, you have to be compliant with the law, which your current policy, I'm assuming, is. But now how do you make sure that you allow people also to take leave, even though they cannot go beyond a boundary of their society, boundary of house and whatnot? Very important to make a change reflective of what your philosophy is. Second, when you're looking at a posh as a policy, what constitutes posh? With the examples that I started with, right? I mean, they may not have an implication in most of the cases. That might be just a grievance, or maybe a situation that a person came. But it's important to make sure that, some of those situations when you're working from home are very clearly addressed in your policy. What is acceptable, what is not, what is good, what is not, what are the do's and what are not, are all very important from the documentation standpoint. So that's a very critical thing. I would strongly advocate everyone, regardless of your shape and size, regardless of whether you are in a growing phase, in not growing phase, whatever, please do that. That will help your company to a large extent. And in a similar way, training of the employees is another critical aspect. Remember, most of the people would not possibly understand the implications of what their actions are entailing, right? They possibly may think a particular. So, for example, we dealt with one particular matter about 2 weeks back now, almost 2 weeks to it. There was a chat that was happening, which was on an official channel. Okay, people have licensed versions of of these softwares as a collaboration tool, and someone used some funny statement in relation to the management and in relation to the overall situation. Okay, and that got caught, and the person was put to a notice and inquiry. And all of those situations could have been avoided. And these are good people. Okay, they are not people who are vindictive. These are not people who are. But for the training, they possibly would not have done something which has an impact on their career. And remember, people losing job today is a problem, and someone losing job because of stupidity is a bigger problem. Okay, overall family gets impacted and what have you. And therefore, training the employees in the new world as to what is right and what is not. It's just not documenting it, but it is also disseminating that in front of the employees, both who are going to join new. Of course, you will do induction, and the induction has to reflect what is the new reality, not the old one. It doesn't work. The new one, and the existing employees as to what is the right thing to do and what is not right thing to do. Simple thing. If water were to go in my laptop, okay, I'm using this water jar, and the water spills over my laptop. Now, who's responsible for it? Now, one way of saying is that, ye to hone wala hai, ye to ho sakta hai. Of course, ye ho sakta hai, but who bears the cost of it? Is the employee not responsible for it? Is that a 50-50 cost bearing, or what happens? Then, if the laptop cannot be replaced in 2 days, what about that loss of productivity? So there are so many issues like this which have an important element looking at overall aspect. And therefore, with the documentation and the policy framing, it is important that that is informed and trained, and the training is imparted to the employees so that those issues don't come to the fore more often than not. That's my submission. And you are the people on the HR side who have to effectively drive this internally and make a very clear statement in terms of what is coming and what is not. And last that I would say is that some of you may or may not be responsible for the compliances on the employment law side, but be very, very updated not on the social media and on the media, but on the what the real notification is and what the real order is coming through, what are the changes coming through. Keep an eye on it. It may have implication in terms of how you work, both from good sense and from the bad sense. Maybe some stringent measures like what we had as a Ministry of Home Affairs notification of March 29th, or a leniency as the PF notification that has just now come, reducing the 12% to 10% to help employees tide over the liquidity. So that's just my few things as good practices, Abhijit, that would help everyone in the industry. The idea is not to get into any legal issues, avoid coming to people like me. That is one other advice that I would give. You have a better way of dealing with the situation yourself, and not getting into situations which are most unwelcome and could be avoided in these trying times. We have enough that we have on our plate. We don't want to increase anything as such. Said a circular would effectively mean a diktat, and I may or may not be in agreement with that. So it is a one-on-one situation. Remember that the contract with the employee is one-on-one contract, right? There is so think about it. Persistent, Infosys, QLogic has a contract with Vivek, okay, and it's a one-on-one contract, and therefore I have to be respected as me as individual, and my consent individually has to come. What happens is, most of the time people will accept it. There may be two people who would say that, look, I never consented to it. If you had known about their non-consent, you could proactively take an action which is, in his interest and your interest, and come to a non-confrontation situation. This diktat of saying that 25% across board is the genesis of issues that we have seen come to the labor office, because people did not speak one-on-one and did not take that effort of dealing with the person and with the dignity, which is what the employee is expecting in these times. Okay, we have seen when spoken one-on-one, when a letter is given to him individually, not in this as a town hall situation, the responses have been far better, and the solution has come through with the employer and the employee and the leadership speaking to that particular person. But as soon as you do a broadcast of it, the reactions have been really, really horrendous. No, that's not the Supreme Court order. Doesn't give it does not give you a recoup situation. That's not the way it is going to go. All that it says is that it also doesn't say, by the way, okay, that you go and terminate en masse. That's not what the Supreme Court will ever say, or the ministry will ever say. That's not the point. All that it has done is put me as well in the same situation prior to March 29, 2020. Okay, it has done nothing different. The law continues. You are not without any law, okay, restriction. You are bound by law. You are expected to follow the law and then take action. There is no added flavor of the ministry's diktat. That has been taken off the table, but it doesn't mean that you have, free as what is in some countries as fire at will. Okay, it's not employment at will. We still are governed by our regulations, and they will continue to be have to be followed. It's not India is governed by the Indian regulation and not by the US regulations. And I've had several calls, and at times I feel really bad when some of these comments are made from the Indian context. I think we have very fair system of allowing a natural justice. We have a very fair system of giving a particular notice, and you can't paint, because see, remember, what is law? Law is reflection of what society we live in, right? We are not living in the US, we are not living in the Europe, we are living in the Indian conditions, and therefore the laws which are correct from the Indian context is what are the laws that are, whether we like it or not. Okay, by the way, those are reflective of what our society is, subjected to, and what is our society in it actually. And therefore, you cannot just apply what is applicable in the US. The laws of India will apply to the Indian companies. Whether if you don't like it, you're not there in India, right? I mean, you don't need to be in India as clear. I'm very clear about that. If you don't like Indian laws, don't come to India. But if you are in India, you must follow Indian laws. There's no second thought to it. The US laws will not apply. The US laws cannot apply to the Indian situations. Again, it's a precarious situation where there is no work, there is no money. Uh, Again, it's not the employee's problem, Abhijit, that there is no work. He is available to work, right? He is making himself available, so it is not a problem. And you have bench situation in a normal case as well, right? For growth, you keep bench. Then in this situation, when you are forced because there is no work, and I have all sympathies around this fact that there is no work. Now you have an ability to take action as you think appropriate, because that circular no more exists. But doing a leave without pay, doing anything which is a change in the employment terms, would require a consent of the employee. If he consents and he says that, I'm okay because I know the situation, I can be on the rolls of the company, I would be on leave without pay, that is perfectly in order. Remember that you will possibly have to evaluate whether you want to, you have to pay his statutory dues to the government, which is PF, ESIC and whatnot. His gratuity may continue, minimum wages may have to be paid for him to be on the roll, and so on and so forth. So the answer is not in yes or no. The answer is definitely have to be with the consent. And with the consent, you need to ensure that the bare minimum legal provisions have to be followed if the person continues to be on the roll of the company. That's a question that comes from an experienced person, and there is no yes or no answer to it. I believe people, as what you saw, there was a lot of CII, FICCI, MCCI, everyone put their grievance to the ministry saying that, and then it went to Supreme Court. My sense is the lawyer community is going to be busy with all of this, which is the worst thing to happen, where people start to fight. But I do see that there will be a lot of disgrunt amongst the employer-employee situation. There will be a lot of mistrust situations if not handled well, and a lot of situations where there will not be yes or no answer to the situation, and therefore, unless the government comes with something which is a just situation for the employer and the employee, this has a potential of reaching to a situation where the disgrunt will be far more than what we are seeing at this point in time. Therefore, as I said, that your expectation has to be communicated with the changed policies that you need to frame, Abhijit. And once the expectation is communicated by way of training, then you are in the right to expect a particular conduct from your employees. And therefore, as I mentioned, if you want a culture where, say for example, in my office now, we expect our team to fill in the timesheet. Okay, the timesheet is important because when I bill based on the time, the client rightfully expects that what time did you spend on my particular project or my particular assignment is very clearly articulated. Now, if they don't do it, unless I tell them what is the consequence, it is not correct on my part to take a specific action. If you therefore communicate with them as to what is expected as a behavior and what is not expected as a behavior, and then the consequence will follow if they do not take corrective measures or they do not do a course correction on their behavior, then obviously they know what the consequences are, and then you will be legally entitled to take as well, because it is very clearly communicated, articulated. They've been given training, they've been given sufficient time, and then you have taken an action. Then in the court of law, if it goes in that way, you still will have a chance of defending yourself, because you did everything what as an employer you ought to have done. I'll give you again, as lawyers never give a yes or no answer, right? So I'm going to do the same on this question. So let's look at the situation. What we are now starting to recommend is on the documents. Okay, I'll come to this question of the real situation, but let's look at the document. We have started to recommend people that when someone is signing something, and he can tomorrow say that I never signed that particular document, you must make sure that there are platforms which are now available, which capture his photo, which captures his, what you call the IP address. It captures his location and whatnot. Those are authentic platforms someone should start to use very clearly, because you don't want egg on the face at a later point in time that someone claiming that I never actually signed what you rightfully believe that he has signed. Point number one. So like what we have come up with a solution with, of course, people, not that we do it ourselves, but with partners that we have now found out. And we are strongly recommending people to use that as a platform. Very cheap, but very important to do that as such. Things will evolve and tools will come to authenticate as to who the real person is who's actually working on it. For example, there are tools which are now being available where, as you would do a biometric as a physical office entry, you will, as you open your laptop, your face recognition will allow that particular thing to open. And there are checks and balances that the companies are starting to make sure that if there is any person other than the person who's actually allowed to use that particular laptop comes in, that throws as a report with the system administration as to someone else. Obviously, if, for example, my wife were to come on this video, she's not, because I locked that particular door and told that don't disturb. But if someone were to come and, her image is captured at this point in time, then obviously those are off instances. But if someone were to actually work on a laptop which he's not supposed to, all those tools have now started to become available. Remember that all has its cost. Not all will be able to afford, and therefore some of these solutions are, I'm sure, in making. And many of your companies, those who are today on this webinar, must be making some of those solutions which are very, very important. And this is a pertinent point you make. And these are some of the situations that you must write down in your policies to say that if someone is caught doing something which he is not supposed to, what is it that, what we call as tagging, right? People tag people. And why you started with the biometric is because those cards were used improperly. And we have multiple those cases, and we have debated about those, right? That's the issue, Abhijit, that we all have to look at, and the solution has to be found, which is more authentic and which is not adding to the cost beyond a reasonable measure. Okay. So there is no criminal liability at all. Okay. The SOPs very clearly say that if there is only one or two person who get detected in a particular organization, in a particular office, then with a 48 hours of quarantine and a disinfection exercise that is taken care, you can resume the work as such. Till the time you are able to show that you took all the care and the SOP as has been put up, has been followed to the hill, there is no reason why you should be afraid, and there is no action that is contemplated. There was a fear in the mind that got clarified in no unclear word, and I can tell you that there is no gray area in this particular thing, that there is no criminal liability to the CEO or the CHRO or the chief of the admin or to the head of an organization. So keep that completely out of that. There is, I can tell you that there is nothing of that sort. there cannot be a situation like this. But if you don't follow the SOP and then situations arise, then the law may take its own course. And what that is not prescribed as such. The Disaster Management Act is, really a hard act on everyone. But, there will not be any criminal liability as such. You cannot, determine whether the employee got infected and got detected positive just because of the work environment, or for that matter anything else as such. And therefore that clarification came, and that is a very good clarification. Reduces, remember that the yesterday the airlines got announced that they will start from Monday, and the minister was asked in the press conference that, do you guarantee 100%? He said that God can't guarantee this, and I agree with him when he says that there's no 100% guarantee of anything, and so is in the office. I don't think we should have that fear in our mind that the leader will get impacted and what have you. Of course, the care has to be taken. We all will take care as such, but there is no coercive action that is anticipated against anyone. Very difficult. I think, as I mentioned, you follow the contract, you follow the process. That's the answer to this particular question. Trying to use a COVID situation in a non-COVID way may not have may not be authentic way of dealing with it, Abhijit. That's the long and short of the answer to this. Yeah, thank you so much, Abhijit, Vinu, to both of you and to your team.